All right, we're in session number 2 now. This is Vying for the Wand, state or local control. This session has that title. The State Water Resources Control Board has been charged with balancing all water needs of the state. Here in Orange County, water leaders have been far ahead of the curve in planning and water management, water reliability, innovation, and conservation. So dealings with State Board were, for the most part, a typical process. That all changed during the height of the emergency drought, when you likely remember getting much more familiar with the State Board as conservation mandates came down from Sacramento, turning some agencies completely upside down. Some fear the state is vying for the wand, that is, taking away our local control. And now the State Board's influence is continuing to grow. Now, into that realm of enforcement, that's where our next guest comes in. David Rose is an attorney with the State Water Resources Control Board's Office of Chief Counsel. He advises the board on issues involving state and federal environmental law, with an emphasis on water rights, water conservation, and more, including some of the board's broad authorities and newer roles addressing homelessness near bodies of water and other controversial water issues. Please welcome David Rose. Hey, David, pleasure to meet you.
Good morning. I think I have a PowerPoint presentation. I don't know if I need to cue that up. Oh, there it is. So, lucky me, I get to follow professional future predictors with a history lesson. You probably saw session 2 starts with more than 40 years ago. And bear with me, okay? So, not only is it a history lesson, it's a history lesson about a regulatory agency, the state regulatory agency that's vying for the wand here, and I get to do a PowerPoint presentation, so you are in for a treat. But please keep an open mind. Remember the sage words of Rafiki, advisor to the Lion King, who said the past can hurt. You can either run from it or learn from it. So, for the free history lesson this morning, what can I say except you're welcome? And I feel like I'm checking my... No, is this moving here? There we go. I thought I was forgetting something. All right. My comments today are my own. They're not even my own. They're nobody's comments. They're not the State Water Board's comments. They're not any board members' comments. They're not the governor's comments. They're not your neighbor's comments. Anybody you can think of, these are nobody's comments, okay? You know, these aren't the quotes you're looking for. So, two pertinent things to keep in mind as I give you this history lesson. One, just because it's what's done doesn't mean it's what should be done. And even miracles take a little time. The first one was Cinderella, and the second one is her fairy godmother. So the directive of the State Water Board is to preserve, enhance, and restore the quality of California's water resources and drinking water for the protection of the environment, public health, and all beneficial uses, and to ensure proper water resource allocation and efficient use for the benefit of present and future generations. The 5-member State Water Board allocates water rights, adjudicates water rights disputes, develops statewide water protection plans, establishes water quality standards, and guides the 9 regional water quality control boards that are each located in the major watersheds of the state. You probably know a lot of this already. The regional boards are each comprised of 7 members, and they serve as the front line for state and federal water pollution control efforts. That's their charge. Since its creation in 1967, the State Water Board and regional water boards have followed the original mandate to balance, to the extent possible, all uses of California water resources. As you've already heard, today's challenges are many, including rapid population growth, continuing struggle over water allocation between many competing and valid demands, and addressing new sources of water pollution control. Water Code Section 102 provides that all water within the state is the property of the people, but the right to the use of water may be acquired by appropriation in the manner provided by law. These rights are called usufructuary rights. They're use rights. You don't own the water. You own the right to use the water. And the right to the use is limited by the amount of water that may be put to reasonable beneficial use, some of which are shown here: drinking water, that's agriculture, fish and wildlife, Beneficial uses include, like I said, domestic, municipal and industrial, irrigation, hydropower generation, livestock watering, recreational use, fish and wildlife protection, and so on and so forth. You can see the regs if you want to. California water rights law, you've already heard, I won't go into it, is different than it is in the East because of two main factors. That the water, when and where the water falls, is not the same place and time as when and where the water is needed for the most part. We have a flashy system, and we have a big state, and we have to transport water to where it's needed quite often. The other basic reason our water rights system is extraordinarily different from eastern states is how valuable water is here. It's not to say it's not valuable on the East Coast, but man, water's worth a lot to everybody here. The main two types of rights to acquire and use water are riparian and appropriative rights. There are others, federal reserved rights for federal lands that are set aside to serve those uses, and then also pueblo rights. I don't need to get into that, but it's from Spanish and Mexican law. Riparian rights entitle a landowner to a share of the water flowing past their property, but it doesn't cover storage or diversion for use off of the property or outside of the watershed. The appropriation doctrine applies to basically everything else. I think the quote is, any taking of water other than riparian and overlying uses. This originated in the gold rush days, probably along the same time as the great quote of whiskey's for drinking, water's for fighting over. And we can meet afterwards for one of those. But the miners, they just went out there and did it. They took water for their placer mining claims, and they developed their own priority system of first in time, first in right. Whoever got there first, whoever put the water to beneficial use first, got the first right. Everybody else was subsequent or junior to that right holder. And the court subsequently affirmed that system and said that merely by diverting water and putting it to use, you have a right to do it. Now, this rule was superseded in 1913 by the enactment of the Water Commission Act, which created a water commission to provide for the orderly method for the appropriation of unappropriated water for useful and beneficial purposes. And then by amendment in 1923, the statutory procedure became the exclusive means of acquiring water rights. So no more going out and just doing it. That's not okay anymore. I'll touch briefly on the priority system because you probably don't need to know it that much for this purpose. Riparian rights generally have higher priority than appropriative rights, but they all share in the cutbacks if there is a need. If there's a drought, then everybody takes a correlative cut. In times of drought and limited supply, under the appropriative system, junior right holders, they just get cut off. So if you're last in line, you don't take a correlative or a share cutback. You're cut completely off until the more senior users are completely satisfied. Pre- and post-1914 water rights are essentially the same type of water right, except post-1914 water rights, meaning those initiated through the board or its predecessor after the 1913 Water Commission Act, they have a greater degree of regulatory scrutiny. You can dispute the difference between pre-14 and post-14 rights with me another time. Back to the board. The role, because that's what I'm talking about here, the board. The role of the Water Board under the 1913 Act was a very limited one. The board was only given authority over water that was not yet appropriated. It was not given authority over existing rights. And the court said as much. They said the function of the water board was restricted to determining if unappropriated water was available. And if it was, and no competing appropriator submitted a claim, the grant of an appropriation was a ministerial act. No discretion, just stamp. That must have been fun to work for that board. So unsurprisingly, the conflicting nature of California's dual water rights system, appropriative doctrine and riparian, and of course, water being something people like and is valuable, has prompted legal disputes. A 1926 California Supreme Court decision, Herminghaus versus Southern California Edison, held that riparian right holders, unlike appropriative right holders, were not required to put water to reasonable beneficial use. It's kind of weird phrasing, not required to put water to reasonable beneficial use. What the court said is that they can waste water. Riparians, they can just waste water. They can do whatever they want with it. The clash between the two systems resulted in a constitutional amendment requiring all water use to be reasonable and beneficial, which I think is kind of a good thing. The reasonable use doctrine, and this is a really boring picture of that, but nonetheless, it's got a citation, so that makes it fun. Article 10, Section 2 describes the reasonable use doctrine, which is, the courts have said, one of the overriding features of California water law. I'm just going to quote from one part from it. The right to water or the use or flow of water in or from any natural stream or water course in this state is and shall be limited to such water as shall be reasonably required for the beneficial use to be served, and such right does not and shall not extend to the waste or unreasonable use or unreasonable method of use or unreasonable method of diversion of water. Oh, they can't write them like that anymore. That's, lawyers used to get paid by the word. We don't. So this amendment did more than merely overturn Herminghouse. Like I said, it established state water policy. All uses of water now must conform to the standard of reasonable use. Helpfully, California courts have never defined what constitutes reasonable use. They've generally said not much more than the reasonableness of any particular use depends largely on the circumstances. I'm giving you another great old quote. It cannot be resolved in vacuo, isolated from statewide considerations of transcendent importance. Paramount among these, we see the ever-increasing need for the conservation of water in this state, an inescapable reality of life quite apart from its express recognition in Article 10, Section 2. So, use water reasonably. That's the crux of it. Luckily, for anybody who wants predictability in their water rights, alongside the rule of reasonableness, there's another rule that imposes a separate but similarly potential limit on the uses of water: uncertainty. The state holds the waterways, navigable waterways, in public trust for the benefit of state residents. This is Mono Lake. The National Audubon Society case was pretty much the preeminent case for discussing the water rights system and the public trust doctrine and how the two merged together. So what happened was the National Audubon Society challenged longstanding water permits. These were permits issued by the Water Board for diversion of water from streams feeding into Mono Lake that were dewatering or causing a drop in the Mono Lake levels that were, I believe, environmentally catastrophic was the language they used, something like that. But it showed the TUFA, so that's good too. Recall that the role of the board under the 1913 Act was a very limited one. The board declined to reconsider the permits, concluding it was required to allocate all available water for beneficial use by appropriators, notwithstanding the potential environmental harm of such diversions. The court said no, told the board to reconsider. So in bringing the two doctrines together, the court said the public trust doctrine prevents any party from acquiring a vested right to appropriate water in a manner harmful to interests protected by the public trust. The legislature, acting directly or through an authorized agency such as the Water Board, has the power to grant usufructory licenses that will permit appropriator to take water, even though this may unavoidably harm the public trust. So we can grant, they said that the board can grant a permit that would harm it. They just have to consider it. And the third point, state has an affirmative duty to take the public trust into account in the planning and allocation of water resources and protect public trust resources whenever feasible. I'm going to skim through this slide. I've given this presentation before, but this walks a little bit through the authority of the State Water Board and how the courts addressed the changing role of the Water Board. So the 1928 amendment, like I said, didn't expand the authority of the Water Board. The board was a ministerial body with a limited task. Over time, statutory and judicial developments have enhanced the Water Board's authority to oversee the reasonable use and weigh and protect the public trust. So in 1955, the legislature, I don't know if you can even read that at all, but it's just a statutory site. You probably don't need to know that here. I can tell it to you later. The legislature declared the board shall consider the relative benefit to be derived from all beneficial uses of water concerned and may subject such appropriations to such terms and conditions as in its judgment will best develop, conserve, and utilize the public interest the water sought to be appropriated. That, very, very different in my mind from rubber stamp any application you get. In 1959, it identified recreation and fish and wildlife preservation and enhancement as a beneficial use of water and determined that the board should take into account the amount of water needed to remain in the source for protection of beneficial uses. A whole bunch of cases, don't need to know, but they walk through the progression. In a 1939 case, the court said, well, I won't quote it, but the court basically said, gee, this system is very frustrating where everybody has to come to court and fight over their disputes one by one and not bind any parties who weren't parties to the litigation. But it didn't say it was changed, it just said that's what it was. So that's Meridian. So now we've got a whole bunch of new statutes that the legislature enacted. Water Code Section 174 grants the power to the board to exercise the adjudicatory and regulatory functions of the state in the field of water resources. Section 186 grants the board any powers that may be necessary or convenient for the exercise of its duties authorized by law. I can't even read what that one says. I'm going to assume it's 1058, which is our rulemaking authority, and then I'm just going to skip on here. So the board has cease and desist authority over unauthorized diversions. I already mentioned 1058. And in 1955, the court held the decision of the board to grant an application was a quasi-judicial decision, not a ministerial act. So that was one of the first affirmative statements from the court that things had changed. I'm going to skip some of these and jump pretty much right to the end, where in 2011, the California Farm Bureau Federation, the court basically said that the board has broad authority over all types of water, groundwater, pre-14, post-14, as to reasonableness. And then all of this led to the decision in Light versus State Water Board in 2014, upholding a board regulation declaring unreasonable and prohibiting certain uncoordinated frost protection. Basically, farmers were going out and frost protecting their vineyards, and that caused a decline in the stream that stranded endangered salmonids. So the board enacted a regulation that applied to diversions under permits, licenses, riparian rights, pre-1914 rights, and pumping of hydraulically connected groundwater. And the court upheld that, discussing what I've discussed here briefly about the change in the board's authority over time. So that, in a nutshell, is a picture of the board's current role, at least regarding water rights. But we don't just do water rights. More than 50 years ago, the legislature recognized we wouldn't have enough clean water for our uses unless water quality and water quantity decision-making were coordinated. So, in 1967, the legislature merged the State Water Quality Control Board and the State Water Rights Board into what we have today. The State Water Rights Board, for those of you following along at home, was the successor to the Water Rights Commission created by the 1913 legislation, and the Water Quality Control Board was initially called the Water Pollution Control Board. You may have seen this if you've been involved in this for a long time, but lots of times the names are changed and the roles stay similar. In the 1940s, outbreaks of waterborne disease, fishing and recreational waters were degraded, and rapid wartime industrial development prompted a new approach to water pollution control that was greatly needed. There were a lot of different regulatory bodies, state, local, federal. That's consistent with us vying with the wand idea here. But guess what? Nobody was happy with the inefficient outcomes of a lot of different regulatory bodies with a lot of different rules. So all interests, urban, industrial, agricultural, recreational, sought more efficient and equitable water pollution control rules. In 1949, legislature enacted the Dickey Water Pollution Control Act, which created, as I said, the State Water Pollution Control Board. I'm going to skim through to get to the fun part here. You wanted to hear about emerging issues, I imagine. The Dickey Act created the 9 water pollution control boards that we pretty much have today. And then we got a big boost with the Porter-Cologne Water Quality Control Act in 1969 that the Federal Clean Water Act was actually modeled on. You may or may not know that. Fun little bit of trivia. But we were first. And only 100 or so years after tackling surface water, the Sustainable Groundwater Management Act of 2014 added a small degree of authority to the board, for the board to act as a backstop. This is a picture of groundwater, by the way. Added a little bit of authority to the board, but the crux of this SGMA, the Sustainable Groundwater Management Act, is, well, I'll just say it. It's the policy of the state that groundwater resources be managed sustainably for long-term reliability and multiple economic, social, and environmental benefits for current and future beneficial uses. You're going to like this part. Sustainable groundwater management is best achieved locally through the development, implementation, and updating of plans and programs based on best available science. So the board is a backstop. The board has a very limited role in this. We also got the drinking water program. I say that like it was an NBA trade or something. It's not Kevin Durant. But the State Water Board got the drinking water program from the Department of Public Health in 2014 also. That was a busy year. I won't go too much into what they do, but essentially the drinking water program has primary enforcement over federal and state Safe Drinking Water Act and is responsible for regulatory oversight of about 8,000 public water systems throughout the state. So what's new or newer? Conservation is a big crux of this, not my panel, but everybody else's panel today. So I'm not going to go into depth on it, but I definitely want to point everybody to the California Water Action Plan. It's the top one in those three documents, and an executive order implementation report from April 2017, and then newly enacted legislation. That's pretty big. SB 606 and AB 1668 were signed by the governor yesterday to enact a broad program with a long timeline for making water conservation a California way of life. But the newer new stuff, cannabis. In October 2017, the board adopted a cannabis cultivation policy and general waste discharge requirements. The purpose of the cannabis cultivation policy is to ensure that diversion of water, this is a water rights and water quality policy, so it's addressing both because there's both potential impacts. It doesn't have a negative impact on water quality, aquatic habitat, riparian habitat, same as everything, it doesn't hurt anything. It applies to essentially all cannabis cultivation activities, except for those 6 plants that you have at home for personal use. That's Prop 64, so completely different. There's also, the regional boards are tackling this more than the state water board, the impacts of unsheltered communities. That's an interesting euphemism, but homelessness essentially can often look like this. And so the Region 2 San Francisco Bay Regional Water Quality Control Board has been addressing this since 2015, essentially through trash cleanup efforts, trash reduction loading efforts. Region 9, the San Diego, I'm jumping ahead here, San Diego has addressed it from a bacterial standpoint, essentially, or is looking to it. There's a tentative investigation order, not adopted, tentative. You can still comment. It won't be adopted until possibly August 8th, addressing a number of cities and municipalities for bacterial impacts. And then the Region 8 Santa Ana Board has been talking about this as a human right to water issue as well. So there's different approaches to this. And I do want to mention that there was an MOU between the city, Memorandum of Understanding, between the City of Riverside Housing Authority and SAPA to do research and plan and conduct feasible multi-benefit projects. I think that this is a really good thing. This is why I'm giving a shout out to this one, because NGOs are often much better at fundraising than regulated entities like cities are. So getting people to use what they're best at and come together to solve a problem, I'm always for that, kind of a good synergy of needs. And these were going to be somewhat animated, but change is good. That's Rafiki sitting on the top there. Sometimes the right path is not the easy one. That's Grandma Willow, the big tree with a face on it, if you don't know Pocahontas backwards and forwards. And if you don't know where you want to go, then it doesn't matter which path you take. I want to pretty much close on that one because we're vying for the wand here. So thank you, and I hope you're satisfied with your care from the water boards. And I think it's time for questions. Sorry I went over.
Thank you. Come on over, David. Thank you so much. So, with the state board's enforcement arm, there we go, growing, are we going to see state board enforcement patrols out, keeping an eye on what's going on throughout the state?
Well, we have a lot of... Does it sound like it's on?
Yell into my lapel.
No.
Okay.
So we have all these helicopters, these black helicopters, but we don't have enough gas, so we're working on it. No. Board enforcement hasn't changed. If you read carefully through SB 606 and AB 1668, when you wake up again, you'll see that there's not really a change in board enforcement from any of that. So most enforcement, depending on what you're talking about, if it's water rights enforcement, the board will continue that. If it's water quality enforcement, the board will continue that, and the regional boards, that's what the tentative order for that I mentioned that was potentially addressing bacterial issues in San Diego County was. But for most conservation things like watering your lawn when it's raining, most of that, municipalities have their own ordinances and will continue to enforce those things. Does that answer your question?
Yep. I love the concept that you introduced at the beginning, first in line, first in right.
I made that up.
You did. But that goes back to the history of water use, and you mentioned the gold miners. But give us an example of how that would play out in our sort of current time and current necessity? Would first in line be like the agricultural interests in the middle part of the state?
So I usually say that when I'm describing water rights, you can only look at it from either 10,000 feet or 10 feet. Anything in between is just too difficult. So the agricultural interests in the middle of the state, some of them have very, very senior water rights, and some of them get water that is from the state and federal water projects. So those projects are junior to the direct diversions. I'll give the Kern River, for example. The Kern River was essentially fully appropriated, every drop of water, even before 1914. So that was largely for agricultural use. But every river is different, and so water that's stored in the federal and state projects, that water is their water. Even though they're junior in right, they've stored that water, so a senior diverter can't take it. It's not theirs. So yes, most of the diversions...
So they're junior in right because they got in line first? How come it's not assessed as to necessity?
Takings? I mean, it's not assessed as to necessity. Reasonableness and public trust are overriding factors for all water rights, but you can't really change the system that you've had forever. Now, there's not a whole lot of mining claims anymore, so some of the initial diverters and the initial uses aren't still occurring, but agriculture has been occurring for a long time. The delta was reclaimed. Maybe I didn't need to air quote that because it's the real term, but was reclaimed more than 100 years ago, and so a lot of the agriculture in the state are the senior right holders. But there are also a lot of agricultural diversions and uses that are occurring under junior rights. Municipalities, I mentioned Pueblo rights. Those can be senior, but there aren't a lot of Pueblo rights because there aren't a lot of municipalities with their water rights stemming from Mexican law.
Right. Awesome. Anybody lined up at our microphones that would love to ask David a question? Nobody? So what are the issues that your office is most focused on right now? Current litigation, current legislation that you're trying to forward or raise awareness about?
I can't say, and I don't mean I won't say, but we have 50-plus attorneys, and I work predominantly on water rights and conservation. The legislation that the governor signed yesterday, that's a big one. That's making water conservation a California way of life and adopting a efficiency approach. But that's not for agricultural water use. So there's lots of pockets, and they all have their own rules. The Drinking Water Program Transfer and SGMA, the Sustainable Groundwater Management Act in 2014, those were huge. So I'm super busy. We've been sued on everything we can be, and I'm busy.
There you go. Yes, sir.
Thank you. My name is Art Kidman. I'm a water lawyer for more than 40 years. And you did a really great job, David. Thank you. I congratulate you for being able to cover a big subject. I have one comment, suggestion. The mess, the difficulty in water law is not all due to climate and variability. It's partially self-inflicted. And the State Bar magazine a few years ago had a list of the 10 worst decisions decided by the California Supreme Court in history. Right at the top of that list was Lux versus Hagen, which introduced the concept that we've got these, as you mentioned, riparian and appropriative rights that are intermixed, and so the system is very, very difficult legally. That was continued to groundwater, by the way, with another case. My question, though, is more what your subject was. What the changing role of the State Water Resources Control Board. Art Baggett, chairman of the board for many years, used to come to the Aqua Conference. I know you followed in those shoes a couple of times as well. But he made the point rather frequently that the water rights portion of the State Board's staff and resources was very small, made less than 10% of the total budget. the balance being on the water quality side. And certainly there was very little regulation on the water quantity side, the water rights side. Now, as you said, there's this huge growth in the last few years of the board's authority over water supply compared to not that long ago. Have those resources grown as well? And is the board able to carry out these new authorities effectively?
So thank you for the question. Yes, I think the board is definitely able to carry out its new authorities effectively. Luckily, I also work on employment issues for the board, so I know how many people we have and where they are and what they do. And I also work on water rights fees. So it's definitely grown in terms of the water rights program. And I agree with you that the system that we have, I jokingly said takings was the reason we don't have a change, but it's not that far off. The system that we have may run into some issues if somebody's 100-year-old water right was for diversion of natural flow of a river that doesn't flow in that month anymore, because there's a seasonality component to water rights. So I don't know what's going to happen when climate change changes when, where, and how the water falls, because the rights don't have flexibility in them. The appropriative rights doctrine says that if you're junior, you get cut off. If something's outside your right, you don't have a right to it unless you get a permit from the board. But how are you going to get a permit if there's no water available for that? There's no water available. So yes, the board has, I think, the resources, but if you want to talk to anybody about giving the board more, that will always be good. I'm sure that that's what everybody's position here is that the board, vying for the wand, right, is that the board should have more authority. That's what I understood this to be about, right? But we're doing the best we can, and we want to work with the regional boards, work with the locals, the local municipalities to address, like I said, the mission or the directive of the State Water Board. We're all trying to work together here, I hope, or at least that's my approach.
Great job. Any last questions? Let's give David a big round of applause. That was awesome. You had a great sense of humor. Yeah.